It doesn't make a nasty.
Do y'all hear me now? Can you say something, please? Is it Boone?
No, we can't hear the judge.
Can't hear the judge. I think it's on y'all's end. We cannot hear the judge.
But we hear other things.
All right, do you want me to hold on this end?
Counselor, can you hear me?
Yes, I can.
Mr. J, if you're able to start over and pick up, or rather than pick up where you left off, start over on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Birkeland, my understanding, is no longer being called as an expert to testify, but is only being offered in some kind of advisory capacity, and all efforts to depose Dr. Brannon have not borne fruit yet. You can pick up where you've left off.
Yes, we have tried to get that coordinated and have had no success with opposing counsel. I am not even sure what this person will testify about. I don't know if it's another battered spouse syndrome expert. Florida law seems pretty clear that any other mental issues would have to be insanity. So I'm not sure exactly who this doctor is. We had prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to trial.
Okay. Mr. Owens, with regard to Dr. Birkeland, is Mr. J's position that that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J?
No, sir.
Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and I'm going to be down there Monday night, and I'll be available all next week. I can do it at any time. The only two things I've got is the Dr. Harper's deposition on October 1 and the state's expert evaluating the defendant, Sarah Boone, on Wednesday, October 2nd. But I'm free anytime, and we can make Dr. Brannon available any day that week, I would assume. We just have to get with him.
Mr. J?
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the to require the production of a report?
Under 3220F, you and your discretion could order it to speed these proceedings along so that I do not have to engage in a fishing expedition for an inordinate amount of time on the eve of a trial that is set to occur on October 7th, when I am unavailable on Friday next week due to an insanity placement hearing in Osceola County that has been previously scheduled and rescheduled numerous times. I am not opposed to working on Thursday, but Thursday is a court holiday, so we would have to make arrangements. And then Wednesday,
If there are other persons in the media who are appearing virtually to observe this proceeding, I need you to mute yourself, please. There's an individual by the name of Lou. Sir, I need you to mute yourself in order for the court to conduct its business. Whoever is participating in the hearing this afternoon, whose name is Lou, if you can hear me, this is Judge Kranick. I need you to mute yourself, please. Mr. Owens, how are we going to be able to coordinate this step? Well, let me hear from you. Let me go back to you, Mr. J. 3.220F says, on a showing of materiality, the court may require such other discovery to the parties as justice may require. And is that your position that that allows me to provide written reports?
Yes, it is within the court's discretion to order an expert who has not produced a written report, nor have I gotten his CV, to produce a report in efforts to coordinate discovery with opposing party.
Mr. Owens, what's your response?
Judge, my response is it's a narrow issue, battered spouse. Dr. Brannon is an expert. You know, I've mentioned him 2 or 3 times. He testified in the Marsha Thompson case in Palm Beach County. That's his field of expertise. It's not going to be a fishing expedition in his deposition. It's going to be related to that sole issue, battered spouse. And I'm available Thursday. I realize that's a holiday, but I'm available as well. I can make him available. I'll do everything I can to set the deposition as soon as possible.
Do we know of Dr. Brannon's availability?
I can try to get him on the phone now, Judge, if you'd like me to.
Any objection to doing that?
Dr. Brannon's phone number.
I don't want to burden.
Coordinate the deposition.
I don't want to burden the court. Judge,
Mr. Owens.
I have a pool camera in here. There is no need for anybody else to be on the line except for Mr. Owens.
I can't control that. The media reached out to court admin today and said they were going to be hearing virtually. I'm trying to log in to my app to silence this other person.
I'm having difficulty.
I'm with you on the difficulty scale, and I sympathize with it, but I don't have the ability to remove him at this time. I'm working on it right now.
If he is available on Thursday, then that will be our preference, because it's my preference to do it in person.
Fine. That will be an in-person deposition no later than Thursday of next week, the 3rd. If you are unable to have that deposition coordinated, you need to let my office know immediately, and we will set a hearing as necessary. I'm in trial next week, but I will make the time in order to make that happen.
He is living or working as listed on the witness list in South Florida. So under the rules, the deposition should have to occur there, unless Mr. Owens is requesting a different location.
Mr. Owens, are you requesting a different location other than South Florida? Where's the location of Dr. Brannon?
Well, we'll ask Dr. Brannon, but if he's willing to come up here for the deposition, I'm fine with that. Or we can travel, whatever. Or we can do it by phone or Zoom. I'm available, like I said, all week next. I'll do whatever is necessary to get the case resolved.
It's going to be an in-person deposition, so the issue is simply location, whether it's in South Florida where his office is or here.
Doesn't matter to me.
Okay? Then you've got your deadline by next week, Thursday, to take that deposition. I have reviewed the state's responses to multiple matters, including the amended exhibit list and the second amended exhibit list, and a response that the state had filed regarding a second motion. Was there a second motion to suppress that was filed?
Judge, they filed a notice of objections to the state's evidence late last night. Contained within that objection to the state's evidence was basically an unfiled, legally insufficient motion to suppress statements based on a statement made to a patrol deputy prior to the first statement to the detectives in an unmarked patrol car on February 24th, 2020.
Okay. I have not seen that hasn't cleared the court file yet, I don't believe.
Judge, I believe I sent it directly to your JA. Defendant's objections to plaintiff's exhibit list. Would have been sent to Ms. Barrios.
I have.
Last night.
Mr. Owens, the second paragraph of the second page of the objections seemingly refers to a different interrogation than what is made reference to in your motion to suppress of September 24th.
That's correct.
Okay.
May I be heard?
You filed your objections. As of right now, there's only one pending motion to suppress. Is there
That's
another
cool.
motion to suppress that's going to be filed?
I'm not sure, Judge. I had some time constraints on filing this defendant's objections to plaintiff's exhibit list. I put those last two paragraphs in page 2 on there for the purpose of preserving that issue because my client asked me to. Whether or not I'm going to file those or not is an issue that will be decided on Monday when I drive down to speak with her. I may or may not file those, but I wanted to preserve that potential issue, object.
Mr. Owens, can you hear us? Cannot hear you, sir.
Can you hear me now?
Yes, sir, we can.
I'm sorry. That was my error.
What if any response do you have to? My concern is I don't have a complete picture of what is attempting to be filed, and you're telling me you're not going to be able to know until you meet with your client on Monday as to whether or not you're going to file a motion to suppress. We're rapidly proceeding to trial in this matter.
I understand that, Judge. I had a deadline for filing these defendant's objections to plaintiff's exhibit list. Based on my last discussions with Ms. Boone, she expressed concern about those two statements that are on the second page, the last two paragraphs. I simply was preserving the right to make an objection on the two exhibits, which is the body cam of Deputy Rodriguez and the audio tape that was taken, the interrogation that was taken in the squad car by the two homicide detectives. I don't know whether I'm going to even file a motion to suppress on those two paragraphs on the second page. I plan on driving down Monday. I will see her Monday night. We'll make a decision at that time. But I felt like I had to preserve that issue in this objection of these exhibits.
Right? Yeah, we can't hear about that. Because we can't get into a private Zoom meeting. They're not going to let us into the Zoom. You said there was somebody that said they had a Zoom.
I don't know who that is.
Can't we just do it the old-fashioned way? Counsel can call my phone.
Can we pull him in to, can he call over the overhead? Yeah. All right, Mr. Owens, we're going to give you a phone number to call in, sir, because there are so many people that are trying to participate virtually.
Okay.
The clerk is going to call you right, sir.
Okay.
Let me pull up this new one.